Good afternoon and welcome to HR Quarterly Updates number 3 of this year. We are here, Alain Camonier and my name is Nikki de Groot. We are both employment lawyers at Pallas. Today we will discuss a few hot HR topics because there are a lot of recent case law, there's a lot of legislation. But also we see it more and more doing in our practice. We make it. The topics are for Alain, employers' obligations with Me Too. We also will discuss secretly recorded conversations. I will discuss alcohol and drugs relating to employees, and we will finish with some recent legislation and case law. During our presentation, we invite you to take part in poll questions before we start with every topic. There is no right or wrong answer. We just want to know what you are currently dealing with. During the presentations, you can ask our questions, but we can also answer your questions at the end of the presentations. We will focus on best practices and invite you to engage in this presentation. Alain will start with the first topic, employers' obligation with Me Too, which is a hot topic of today, and we see it more and more during in our practice, in case law and in our advice work. And I welcome Alain to the floor, and hopefully you can tell us more about the Me Too situations.
Thank you well. Thank you, Nikki. We have the first poll question. So I think you will have in your screen the first poll. And in addition to the poll, take your time. I'm going to share the results in a minute. I'll give you an introduction of the topic, and we called the topic Employers' Obligations with Me Too. So it's not that we are going to give you an overview of Me Too case law, how that works in the Netherlands, because there's a lot to do with that, and I think everybody has read and heard about Me Too sexual harassment cases in the last couple of years multiple times, but questions we get regularly is that what is the obligation for me as an employer when I have to deal with a Me Too situation, and that is the topic of today. There is a lot going on with sexual harassment cases with Me Too, and I think that is clear. Yesterday we saw in the Dutch newspapers that Investigation Bureau Berenschot issued a report in which their conclusion was that there are 10% more complaints regarding sexual harassment cases with employers than in 2021, I guess. So in 1 year there is an increase of 10% of complaints, which does not mean that there are more cases, but victims tend to complain more earlier about the situation, and that means that you should deal with that as an employer. You can't say, I'm not going to do with anything with that, it's a personal issue, now it is your problem. When I look at the results of the poll, which question was, did you experience recently a Me Too situation in your company? 30% said yes and 70% said no, so that's a good outcome, which means that in most companies it's not a big problem, but 30% still is substantial, and therefore I think it's an important topic. When we look from a case law perspective, from a legal and employment law perspective to sexual harassment cases, say until 2017, and in 2017, October 2017, the Me Too movement started out in the US and spread all over the world after that, and also reached the Netherlands, of course. But before 2017, we always had a problem as lawyers when we had to deal with a sexual harassment case. And that is also understandable because in most situations where a harassment case occurs, it is between two persons, which is the suspect and the victim. And also most of the times nobody else is present. And if someone else is present, or if when it's written, at that stage you have more or less an easy case. But that means that if there is between two persons a situation which cannot be tolerated, and it creates an unsafe environment for the victim, that means that you have an evidence problem, because taking the view that the employer himself, and most employers are companies of course, is not the suspect, at that stage you are a third party as HR or as management or as executives. You are a third party and you also do not know what happened. The question is, who do you believe and what are outside evidence situations? And because of the evidence problem, if you read the case law in the Netherlands about harassment and sexual harassment, in a lot of situations a termination was very hard to realize with respect to the suspect. So a dismissal was a hard case to swallow. A lot of high severances were paid because the evidence was not clear enough. And at the end, the victim was the one who had also or had to leave the company because she or he felt unsafe, and settlement agreement was signed with a high severance, or maybe not so high severance, a secrecy clause included, and that was that, so to say, which is of course also the reason why the Me Too movement started, because of this situation. And from a legal evidence perspective, it is clear, because you don't have a pile of evidence. Proof is lacking. Everything changed after the Me Too movement started, and everything changed. That means it is clear that people were daring to speak out. The social development in general, not only in the Netherlands but worldwide, was very protective towards the victims or presumed victims, and very, aggressive is maybe not the correct word, but not that tolerant anymore against the suspects or the suspected suspects, so to say. And what we see, and how it also should be, is that case law, the law, follows the social impact of a certain situation, because law is more or less something which is written because of what we all in the society think is legally is reasonable and should be the guidelines for everybody. So after 2017, we saw that everybody, or most people, was not that tolerant anymore with respect to starting off with sexual harassment cases, and we saw the same situation in case law. And I will give you some examples in a couple of minutes. And how does that work? So when you as an employer are being confronted with a Me Too situation, what should you do? The thing is, you should take the victim seriously, clear. But that should also mean that you should take the suspect seriously. Of course, if the suspect says it's all true and I'm sorry, at that stage you have a more or less clear case, and then the protection of the victim simply prevails the private situation of the suspect. But in a lot of cases, especially the cases which end up with the court or even with our law firm or law firms in general, it is not that easy to say, because the victim comes with a complaint and the suspect says that's not true, or that's not completely true, or what I hear a lot in our practice, it was at first there was a mutual consent, but now we got into a quarrel and now it's not that mutual anymore. So how to deal with that? And I want to tell you how to deal with that, to give you an example. And the example is as follows. I had a case once where there was an employee, and we were with the employer, which was our client. We were in negotiation about a termination of the employment contract. So we negotiated about the content of the settlement agreement. Therefore, how much should the employer pay, and on which date would the employment contract be terminated? And then all of a sudden, this employee said, yeah, but in addition to our negotiation, I also am a victim of sexual harassment. Okay, where does this come from? And she came with a complete story about this, and she filed a complaint, so to say. And at that stage, everything changed. So it's not that we continued the negotiations as we planned to do, because we were in the middle of it, but we said, okay, this is something we should take seriously. This means that we should help you, protect you, dear employee, because especially if this creates problems, damage for you, that we should take care of. We should also take a good look and confront the suspect with this situation. And that means that as employer, you should do an investigation. That is the main rule. You should investigate what has happened as far as you can do that. You can start yourself first, but if that is not clear, if that doesn't give answers at that stage, you should simply go to a third party and ask an external bureau to help you with the situation and the evidence what has happened. That also means that the suspect should be sent on paid leave, because in theory that is a person who could have created an unsafe situation, but also to protect the suspect himself or herself, because you'll never know whether that's true or not. You should send such a person on paid leave and start your investigation. Lately, we've seen case law where the employer did not start an investigation with a suspension of the suspect, and therefore got a high severance based on a severe culpable behavior, because the employer did not do his work correctly with respect to such a situation. So with respect to the suspect, or more or less the situation in general, you should have a proper investigation, and as far as neutral as possible, therefore the third party, and be aware also after the investigation, you cannot always say, also if the bureau says this likely has happened, an instant dismissal is, based on case law, not always the way to go, because whatever such an external party says, it says something about the situation, about the people who can say something about what has happened, and including the suspect and the victim. But whether or not that will be enough for an instant dismissal is in a lot of cases very hard to say. So what we see in general, if you go for a termination of such a suspect and you have a good case to do so, that whether you go the route of going to court and say this is a dismissal because of culpable behavior, or you go to the court and you say this is a dismissal because of a disrupted relation between the employer and employee, the suspect, and we can't tolerate this person any longer within the company. And of course, in such a situation, likely in most cases, you are also trying beforehand to talk about a negotiation on a termination, the settlement again. That's the suspect. With respect to the victim, you should offer the victim full protection under Dutch employment law. That means that you should take the victim very seriously, should provide the victim help. Also the possibility to speak to a professional. And what you should not do is talk about a negotiation for termination, because if someone is a victim in such a situation, then a termination agreement is not the way to go. And what do I mean by that? There is no termination ground, and that means that what happened in the old days before 2017, the situation should be solved and maybe we terminate the employment contract, or that is the idea of both the suspect and the victim. That will be a very hard thing to do nowadays, especially because a secrecy clause, to agree upon a secrecy clause in a termination agreement, is a very hard thing to do, and it could create all kinds of problems with respect to dissolvement of the settlement agreement at the end, because it could be seen as silent money. And that is, I think you heard that in the situations where The Voice, the television show where the people had to sing before judges, there was the big problem about the secrecy clause in the termination agreement, or in the agreement in general, because that could be seen as a silencer to speak out. So if you come to a settlement agreement because the victim wants to, be very aware of secrecy clauses, because that could have an effect against you. Also different compared to the situation before 2017, it's not the situation that you as an employer should give the victim, when going into a settlement, a high severance, because paying a high severance means, or could mean, that you think that the employer is culpable or even severe culpable for the termination, which is of course not the situation, because you are the third party. And that means that if you want to leave, dear employee, how bad the situation is, and we're very sorry for that, we can't do too much with respect to paying severances, so you can't benefit from the fact that you are a victim, whether true or not true, but we are not going with that idea, and we are willing to pay you a transition payment maybe, but no secrecy clause, no high severance. And if you are to the opinion that the employer is to blame for this, then we can talk about a damage, but that is not a damage because of a termination. So it's not a severance payment. That is more or less a damage because the employer created, or let be created, a unsafe working environment. So be careful. Both suspect and victim should be taken very seriously, but both parties, and especially the victim, cannot benefit from the fact that she is a victim. You should give protection, and the best protection you should give someone, the meaning of Dutch law, is an employment contract and not a termination. I have a question here. Is it possible as an employer to start an internal investigation based on a no-name-based complaints about harassment. And yes, of course, and it's not even so is it possible, but based on the rules which are present now, you should do that, because if you know that possibly there is an unsafe environment, then it's for you as an employer to investigate whether that is true, and if that is true, you should make it a safe environment. And if not, then you have what I referred to a minute ago, the problem that you could that the employee could say, I have a claim because of the unsafe working environment and the damage compared to that. I'm going to end with a couple of dismissal case law situations, and all after 2017. And so I'll give you an idea how things are working, and it's not always that easy. 2019, the court in Den Bosch in Brabant, they had to deal with a physical physical instructions by a tutor, a teacher on a physiotherapy course or school, and he got a complaint that he with massage lessons, which is of course part of the physiotherapy education, that he touched a person where he shouldn't have touched that person. But nobody had seen that, and there were 12 people around that person. At the end, the teacher was dismissed. The contract was terminated, not because there was evidence that he touched the person in certain spots, but the fact that other pupils said, I don't know whether it happened or not, but it was clear that when he had to give instruction, that he always went to the same pupil, and because of that, the contract was terminated. It was not seriously culpable, so no high severance payment, but there was a culpable dismissal. Going a little bit further, a driving instructor also in Den Bosch, who got a complaint of the partner of one of his pupils. Then the school, the driving school, said, okay, this is not good. What I'm going to do, we're going to call all other pupils. Did you experience this? So says something about privacy, I guess. So you are confronted as a pupil. Hey, we got a complaint of your instructor. Do you understand this complaint? Some of the people said we understand it, and this instructor was dismissed instantly, and that was set by the court. The Volkskrant newspaper in the Netherlands also got a complaint of a critic, a writer in the newspaper, that he had a lunch with someone he had to write a review about, and they took that seriously. One day after that, they published a full page in a newspaper saying this is not to be tolerated in the Netherlands and not with our newspaper, and we are going to terminate this employee. At the end, it turned out that this employee had lunches with all writers he wanted to write a review about. The investigation of the Volkskrant was not sufficient, and more or less the Volkskrant did a too quick job of firing this person and also publishing it in her own country, her own newspaper. So 370,000 euros on damages, on fair compensation, was paid. And I would like to end off with so I skip one. We had with the Primark, we had a manager. The manager was very close friends with other employees, so they went out together, etc. But he knew about the reorganization and a redundancy, which he did not tell because he couldn't tell because he was the manager. Then he had to tell it and communicate that those people were being made redundant. He was asked, did you know this up front? Yes, I did know it. And then people together said, we're going to send in complaints of these persons. Also, Primark said, hey, we've got 3 complaints of 3 different persons, so we take this seriously. So he sent out an emoji with hearts, and he liked a photo of someone in a dress, those kind of things. But he was sent out, terminated on the spot because of 3 complaints. At the end, it turned out that it was more or less a bad behavior of the employees to get this manager out. And he was reinstated by the court. But it means both Volkskrant and also Primark, you should do your homework and you should simply make sure that you do a good investigation. And you can't say this is not to be tolerated. We don't know what happened, but we always believe the victim. It's not possible. What are the guidelines? And then I'm going to give the floor to Nikki. Sorry, Nikki. You should have a good known code of conduct with respect to harassment and sexual harassment. There should be a policy included with respect to complaints, so the registration of incidents. If you know that there are risky workplaces or you heard that there is a problem, improve the problem, do an investigation, create the situation where employees can go to a person of trust, an integrity advisor, and make sure that people know where to go to if there's a problem. So keep both victim and suspect safe. And unfortunately, the way to go is investigation and even external investigation. I hope this is clear. I want to give you the floor. Sorry for the time.
No worries, of course. I will discuss something about alcohol and drugs in the workplace and relating to employees, because for you as an HR professional, it's good to know some things about it. It has some overlap with Me Too situations, but we'll come to that. I think if you look at your screen, you see a poll questions, poll question 2. And we want to know, is alcohol served during work events? And then think about company parties, Friday afternoon drinks, festive holiday drinks. We would like to know what are you doing right now at the company? We wait for the answer later on, and I will just share it. Socializing with colleagues is a great team building opportunity, and it has long been part of the workplace culture. Let's say to celebrate deals or promotion, alcohol was a little bit the go-to. What we see now as a tendency is that employers limit or companies limit the use of alcohol to 1 or 2 drinks, or they skip it entirely. And that's for several reasons. One of them is to prevent alcohol abuse and addiction, to prevent people from acting inappropriately. That's the overlap with Me Too situations. Also the potential reduction of work efficiency as a result of excessive alcohol and consumption. Also the staff retention could also be lower. We have the results,
and the results
I'm curious.
Is how many companies do serve alcohol during work time in any event. That is 100% of the companies present.
Okay. Maybe after this HR Quarterly update, I will change your mind. If that's the right thing to do, or maybe you have some second thoughts. Who knows? We are talking about alcohol, but we're also talking about drugs. We see also a raise of the use of drugs in the workplace, and then the most usual one is cocaine, but lately we see also the use of drugs of opioids, and then that's are not so visible. The addiction to opioids. Think about painkillers and that kind of stuff. It's also tricky because that will bring people in dangerous situations. So and also the testing is also a little bit different. It's less obvious with alcohol and the more obvious drugs. From research in the US, which we could learn of course a little bit about that, is that 70% of the people with substance abuse issues are employed. That's a powerful reminder that abuse is not limited to the unemployed. It also highlights the fact that everyone could use drugs and alcohol regardless of the employment status. It's also important to consider how this works out in the workplace. What kind of dangerous situation will occur? Another thing what came from the research is 9.5% of the full-time workers engage in heavy alcohol use. That's quite a number, I would say. And another thing is that the misuse of drugs or alcohol are 2 to 5 times more likely to be absent from work. Sometimes people call in sick and use that as an excuse that for the use of drugs and alcohols. And this is also a link that drugs and alcohol use could also be a disease or an illness. And I will come later to that. What should you do in the workplace? We want to make sure that you can. We saw from the poll questions that most of the time people, it's kind of normal to drink during work events. But what you could also consider is that you can make it a drugs-free workplace or can limit the drinks during work events. And why is that important? Just to be considerate about it, because there are people in the workplace. One of your colleagues could be with a problem, but also with the abuse of alcohol, which can lead to a Me Too situation. As a best practice, we recommend you to come up with an alcohol and drugs policy, and it should be very clear what is allowed and what's not. And also, when it happens, what are the disciplinary measures? And can you say, okay, I will suspend you for 1 or 2 days, and what are the next steps? What you could also consider is that there's a kind of counseling. People could help people with a problem. So also the confidential counselor in the workplace is sometimes a go-to for people with a problem, but also for people who are kind of a victim of the alcohol abuse. Because people could be aggressive, people have an addiction problem. And most of the time, if this alcohol and drugs policy is clear, it's always good that you will act upon this policy. Otherwise, it could also backfire on you, that some employees say, "Hey, this policy is in place, but you will not act on it, and therefore I hold you liable." What I mentioned earlier is also that some employees are struggling with alcohol and drugs addiction. And the question is this an illness? Most likely it's an illness, or it qualifies as an illness, because people are incapacitated for work due to their addiction. In such cases, we recommend the companies to provide support, counseling, and maybe also treatment options. Number one is the well-being of the employee, but also you should take note of potential risks of the co-workers, of clients. What are the risks in the workplace? If somebody is calling sick himself, then the usual procedure will start. but otherwise you should encourage the people to engage with the company doctor and follow the process. And it's very hard sometimes because people will deny they have a problem, but at some point there is no way back, and it's a true illness. Also good to, if it's an illness, it's good to mention that employees are, like sick employees, also protected. Think about the continued payment during illness. Think also about the protection during for termination. They are like an ill employee, a sick employee, and are protected. The question is here, at what point is the alcohol drugs use turns to an addiction, and therefore it's an illness. What we also should mention is that at some point alcohol and drugs addiction is already an illness, but could also be shifted to a chronic disease. That gives the employee even more protection. But the question is here also that if somebody has a chronic disease, then it's out in the open that somebody is an alcoholic and it's public. And that's something that most people want to prevent. So it's a stage we don't see that very often, but as an HR professional, you should take note of this. This is a possible option that this addiction will be a chronic disease. When is this a chronic disease? If it's a long-term physically or mentally impairment, and that you are prevented from fully participation in your occupational life. Then the legal framework when addiction, alcohol addiction and drugs addiction becomes is an illness, and then or chronic disease, and what's the legal framework? I already mentioned if the addiction turns out that is to be qualified that you're ill, the employee enjoys the protection of that the employment contract cannot be terminated, and the other protection is for people with a chronic disease. That gives also the protection that somebody cannot be terminated easily. And if you want to terminate somebody with an addiction, then somebody has the protection. But what is actually the ground for termination? That could be that somebody is not performing, but can you link the performance to the addiction, or was it also before? The misconduct can also be a reason. Somebody is more aggressive or yelling or behaving in another way than he used to do. Most of the time it's linked to this addiction. So we should see it separately, kind of, but it's kind of impossible if it's an addiction. In some cases, if there's severe misconduct, you can think about immediate dismissal. But most of the time, again, it's related to the addiction. And we see court cases that the judge rules that this instant dismissal is not valid because this behavior was related to the addiction. And that's kind of, sorry to say, an excuse to behave that way. And then it cannot be that the employment contract can be terminated. I have 3 court cases, but I will be rather short because of the time. And you can of course look them up. I think the lessons learned from case law is in all those 3 court cases is that the addiction, and it was in one in the first one it was a drug addiction, in the second one was an alcohol addiction, is always considered an illness. Therefore, is the warning here, addiction is most of the time qualified as an illness, and therefore people are protected, and therefore people can enjoy the continued payment during illness, and therefore it's very difficult to terminate their employment agreement. Again, we run a little bit out of time, so I give the floor again to Alain. And we start off with a poll question.
Yep, the third poll question: do you ever record professional conversations, including video meetings? So you could do your thing with this question. And by the way, a second question will pop up in 30 seconds. And why these questions? Simply because in our practice we see a lot of court cases, but also employment law cases not going to court, where especially the employee says, I recorded several meetings with HR or with the management, and this is evidence and I want to use that as evidence. So how to deal with that, and can you deal with that? For the technical staff hereafter, please question 4, poll question. When you record conversations, do you explicitly notify the other participant in the meeting? So that's the second question with respect to secretly recorded conversations. What is the story? It's not a really thing with respect to legal issues. It's more be aware of how it works. When you secretly record conversation, it's for everybody. If you record something secretly without being present, that is a crime. So that is mentioned explicitly in the penal code in the Netherlands, wetboek van strafrecht, and there is the lowest penalty is 3 months, which is mentioned in the code. So seriously. By the way, if I see the results of the number 3, do you record meetings? 50% says yes, 50% says no. And of the people who record, 88% say we will mentioning that upfront. 12% says we do not. So, and therefore, if you now I'll come to the GDPR. By the way, secretly recording with being present is not a crime. That does not mean that is tolerated under civil law or unemployment law, but from the crime scene it is being taken out. Of course, another issue to be taken in consideration is GDPR privacy aspects, and that means that if a private person is secretly recording when being present, of course, otherwise it's a crime, GDPR is not applicable, so there is no breach of privacy or whatever. However, on the other hand, if you as a company or a representative of a company record a meeting with an employee, GDPR will definitely be applicable because you do something with data of a individual. And that means that if you record something as from the employer side, of course you can do so, but you should mention that. There should be a reason to record that, so that you should mention that you're going to record it, and you should mention the reason why you record it. If not, that's a breach in the GDPR, the General Data Protection Regulation, which could lead, and there are many case law cases on that, which means that could lead to a higher severance, because that is severely culpable behavior from the employer's side. So be careful on that for the 12% who don't tell that to the participants. The Supreme Court in employment law cases, and I switched to employment law. Supreme Court already almost 10 years ago said that if an employee, because an employee can record secretly as long as he or she is present, that can be seen as unlawfully obtained evidence. By the way, unlawfully obtained evidence is something which comes from criminal law and not so much from civil law, but it's also a term used in civil law. However, the Supreme Court says, although it's unlawful recorded by an employee, that evidence may be taken into account in employment law cases because it's important to find the truth. So you can say, sorry, this is not to be tolerated, and if we had known up front, then we wouldn't have said anything, and therefore unlawfully obtained and you can't use it. That is not the situation. Being present physically or online is a question I get from the people. That's a good question because we are, of course, in the online Teams and Zoom community. To be sure, I don't know exactly. I can imagine that if you are also online present, that should be enough. Simply because that is how it works, but I don't recall that there is case law on that specific issue, and also Nikki is agreeing with me that she also doesn't know it. So we both don't know that is available, but I take the view that it can be online present as well. Although that the Supreme Court mentioned that unlawfully obtained evidence can be used, there are multiple cases, as for example also the court in The Hague in 2022, which said that a secret recording of conversations by an employee at the end led to a termination because the employee could not be trusted anymore. So it disrupted relation. So it's whether or not you can use that as evidence. Be aware that as an employer, I would still say you can't tolerate this. And if this is harmful to the relation, it could definitely lead to a termination. By the way, that means in most cases that you still have to pay a transition payment. On the other hand, there was also in 2022 the court in the north of the Netherlands where a employee had a conversation with the general manager, secretly recorded, and this general manager promised this person a payment of 480,000 or even more euros, so very substantial in profit shares. And the general manager didn't know that that was being recorded. At the end, this employee used this in court. The court said, the importance of finding the truth with reference to the Supreme Court is very important. This has been said by the general manager, comes from the recording, and therefore I allow this employee a payment of 486,000 euros in shares. So be aware, secretly recorded conversations, you can't do that as an employer, you can do that as an employee. It doesn't always turn out positively for the employee, but you cannot simply block it. And if you do it yourself, please mention the reason and inform always the participants in the meeting. We're going to the last topic, Nikki, and we're not doing too bad with timing.
No. Agree. Yeah, and maybe to add on that secretly recording, it's something you cannot prevent, and it's also something we don't recommend to have a recording policy, because that will bring people on. That will give people some ideas what to do and what not, and probably you don't want to have them recording conversations. Okay, I will say something quickly about the recent legislation. Last Tuesday, the Senate or Dutch Senate voted down the bill Work Where You Want. This was Alain, you can say something about it.
I agree with the Senate.
Yeah, you agree with the Senate. This was a bill which was a hot topic, of course, during the pandemic. Then there were high hopes because the tendency was that there will come this bill. And what is this bill about? It allows people to make a request for adjustment of the place of work. We have already in the law a request of timing but not on where. It should be a place of work within the EU, or for example from home. But luckily we should not, or we don't have to allow such requests because the bill is off the table. Another recent changes legislation is that employees with the state pension age need to be paid maximum 6 weeks during continuing payment of wages during illness. Before it was 13 weeks. What to do if somebody with the state pension age was sick before the 1st of July, then it's still 13 weeks. So only for the people after 1st of July which become ill, they only are entitled to 6 weeks during illness.
And over the pension age.
Yeah, of course. Another thing which is quite recent is that companies can request for a subsidy for activities concerning sustainable employability. That could be all kind of activities. And this is from, you can request from 1st of September up to 30 November 2023. The threshold amount for these activities is 15K. This includes the amount of the company for this company analysis of 5K euros. This subsidy, which is kind of has this HR employment trigger, can also be requested to make it possible that senior employees could quit work earlier and to make room for the new generation, the so-called early retirement scheme. The early retirement scheme, also in Dutch, also called the RVU, will be compensated for 25%. The other activities for sustainable employability will be compensated for 50%. So this could be, and I hope you're in time, this subsidy can be requested for several activities, including this early retirement scheme. I think we touch upon the Whistleblowers Protection Act in our newsletters or in other outings from our firm, but maybe it's good to mention that there is also that this act is also applicable to mid-sized private sector employers with 50 to 249 employees, effective 17 December 23. And what means that for companies? The new act requires the organization substantial change in their reporting frameworks and policy. Basically, it's about that the employees reporting have some more protection. Then, because we have this Supreme Court ruling on the Deliveroo case, in which self-employed persons are qualified as employees, the Dutch tax authorities have provided model agreements to help contractors and their clients make sure their businesses relationships are not seen as false self-employed persons. Some of the model agreements are based on free replacement, and the Dutch tax authorities stated that they will withdraw the approval of the model agreements with free replacement effective 1st of January 24. So if you have this model agreement in use, let's go for another model or another structure. but you should be proactive on that. We also have some case law, which is kind of more relevant in an international context, so to say, but also for just the Dutch practice. I will start with the employee entitled to a sabbatical. This was a flight attendant at EasyJet, and she requested for a sabbatical to go for an exchange in Canada for her studies as psychology. EasyJet, after 2 months of her request, rejected the request. She bought tickets and everything, and therefore she filed a lawsuit in court to claim this sabbatical. Because and she had several reasons for that, but EasyJet could not argue that they have insufficient crew members during that time of the requested sabbatical, because she was requesting it for 4 months, for September, October, November, December. And luckily, there was also an out in the collective labor agreement of EasyJet, because that provides for a career break. And it seems like that the sabbatical could also be qualified as the career break. So this was helping the flight attendant. And also another thing which did not help EasyJet is that they replied very late to the request. So on 3 points, the sabbatical was granted, and number one, that it was requested in time, and they didn't reject it in time. They had made clear during the court hearing. They had it became clear they had sufficient crew during October, during her sabbatical. And the other thing was helping is that there was provision in the collective labor agreement which provides for this career break in the specific period. So she was granted this sabbatical. Looking at the time, I also will discuss the other case. That was about a termination case. It was an IT company which hired a highly skilled migrant. Highly skilled migrant status is a residence permit and a work permit. This particular employee was maybe not performing. There was something going on. They offered him a settlement agreement, but with no clear, reasonable ground. Unfortunately, they didn't conclude a settlement agreement for termination. Instead, the employer has to go to court to dissolve the employment agreement. But the thing was here that there was no reasonable ground. But they did dissolve the employment contract, and because they have disrupted this employment agreement by their wrongdoings, they awarded a fair compensation of 60,000 euros, which shows the company was seriously culpable. The employer did not agree with this fair compensation. It was way too high. Although, if we look at the judgment of the Court of Appeal, they make explicit that you have to take into account the highly skilled migrant status, because they only have 3 months to look for another job, and they really weigh in this judgment that that they have to take this into account, that termination had severe consequences for the employee. And it was kind of factored in the fair compensation. I still have some instant dismissal cases, but I think we ran out of time. We do have an evaluation. We hope you will help us to improve, be better.
So take your phone and scan the QR code.
Yes. And if there are any questions, please email this to us, to Alain, me, or one of our other Pallas colleagues. And
we thank you for your presence.